Hey folks, I wanted to tell you about one of the biggest wrongs I ever righted as a lawyer, and it was a workers' comp case that went all the way to the South Carolina Supreme Court. The name of the case is Brooks versus Benore Logistics, and the Supreme Court decision came out in 2024. The case was about whether my client proved he suffered a repetitive trauma injury. My client was Dale Brooks, who was a delightful fellow who worked as a switcher truck operator, and that required him to haul freight trailers all across the BMW shipping yard in Greer. His job required him to hook up and then unhook those semi-trailers repeatedly, which just required a ton of twisting and turning. In a 12-hour shift, he would move 45 to 60 trailers, which computes to about one trailer every 15 minutes. And wouldn't you know it, he developed low back pain that resulted in tingling in his legs. He went to a doctor for it. At that point, the insurance company was paying his workers' comp benefits, and that doctor concluded he'd suffered a spinal injury with radiculopathy. That is a side effect of a pinched nerve coming out of your spine. And around that time, the insurance company decided they just didn't care. They denied his benefits. We had a fight on our hands, so I went to work. The best and most important thing I did for Dale is get a doctor questionnaire. It's just a simple document I drew up with yes or no questions for the doctor to answer about the key medical issues in the case. And it included the repeated job activities Dale committed every day on the job that caused his injury. Well, the insurance company would not be outdone, so they hired an expert of their own, an ergonomist who testified, or even though he didn't appear in person, he wrote up a report saying that Dale's job just wasn't repetitive. There was just one problem. The ergonomist wasn't a doctor. So we had undisputed medical evidence Dale's repetitive job activities caused his injury. Well, we had to go to trial because the insurance company just wouldn't give up. We went to trial before a single commissioner, and we won. The insurance company wasn't ready to give up at that point. They appealed to the full commission, which is a 3-commissioner panel. We lost. I couldn't believe it. Lucky for both of us, Dale authorized me to appeal that case to the South Carolina Court of Appeals. The Court of Appeals reinstated our victory, and they even quoted my questionnaire as one of the main reasons why we won. The insurance company still wouldn't accept defeat, and they appealed to the South Carolina Supreme Court. Now, here's something you might not know about the Supreme Court. They don't have to take your case. So when they took the case, I got real worried they were going to take our victory away from us and give it back to the insurance company. So here's how it works. You got to file these legal briefs, which are basically legal research papers about the case, telling them why you should win. And then several months later, they schedule an oral argument. And let me tell you, it ain't much of an argument because you are not going to argue with the justices of the Supreme Court. Basically, what's going to happen is you're going to answer their questions and try to fit in a few extra points if you can about why you should win. So I was really nervous. And the reason was, not only are you facing these justices who are looking down at you from this big old podium where they all sit behind this giant panel of dark wood, but they're also broadcasting it through a webcast through the entire state of South Carolina. You can probably still download it from their website. Well, here's how it went down. Because the insurance company appealed, their lawyer had to argue first. The first question he got was something along the lines of, tell me how this isn't a repetitive trauma injury, because it just looks like a classic example of one to me. And I got to tell you, most of my worries evaporated right then and there. So when it came to my turn, I held my own, and I want to give a lot of credit where credit is due. Justice John Few was extremely gracious to both me and opposing counsel about the good job we did, telling us that we did a fine job, which meant a lot to both of us because it was the first time either one of us had ever appeared before the Supreme Court.